We're back on the record.
We're back on the record. Mr. Scherer, what order are you referring to requiring his pre-filed testimony to be submitted prior to his testimony?
Referring to the first order. First order after pre-hearing conference. Dated April 28th, 2025.
Okay, let me get to that. So it's going to be first order after pre-hearing conference. It's filed stamped April 28th, 2025.
Correct.
Okay, go ahead.
Several bullets down on page 3,
Okay,
June 18th, 2025. Deadline for pre-file testimony of all witnesses. Separate deadline for that.
Okay.
I believe all of the parties understood this. This testimony was, every other witness has had pre-file testimony. IBFC even submitted pre-file testimony of someone who was not on the witness list, Mr. Messel. And it's still never been witness list, still never been something. We certainly all understood the pre-file testimony. Prior to the witnesses were listed on the witness.
okay. Mr. Iorio? It's his witness. He's trying to call him. So that's why I would, if anybody else wants to comment, I'll let them comment afterwards. But for right now, it's an objection to his witness.
So Mr. Bell was listed as a captain witness. The pre-filed testimony deadline that council referred to is if you are going to submit pre-filed testimony, the deadline was June 18. But that didn't require a party with a witness listed to file a pre-filed testimony. Mr. Bell's deposition was noticed by council, was taken. He's here to appear for cross-examination with respect to his testimony. And I would have a few questions for him after cross-examination from Mr. Scherer. I don't see a statement in this order that we're referring to said no one that a pre-filed testimony is required if someone is listed as a witness and submitted to deposition.
So that order says on page 3 at the 1, 2, 3, 4, 5th bullet point, June 18th, 2025, deadline for pre-filed testimony of all witnesses. Did I read that correctly?
You did?
So I guess here's my question then. Well, let me hear. Does anybody else have any comments on this?
Sure. On behalf of the applicant, it was our understanding that pre-filed testimony was not mandatory or a condition precedent to the ability to testify. For example, on the witness list for Desert Cab, we listed members that aren't part of the client. So we would reserve the right to call them whether or not they did file pre-filed testimony.
Okay.
And I think there was also an incorporation of local rules. If you can recall, NRCP 16.1 just requires listing the witnesses, which they've been done.
Okay. Mr. Tomlinson, anything?
No, I agree with just said.
Scara, do you have any comment?
Yes, well, I don't have a counter. I think it's just more of a conundrum. And the question I think before the board is, do you want to hear what Mr. Bell has to say? I will say from the administrator standpoint, we did rely on the testimony of Mr. Bell that was given his deposition, regardless of the fact that he did or did not file his pre-filed testimony. I also kind of question how those rules would apply to all the parties, because I can say for myself, on behalf of the administrator, we didn't submit a witness list, but we did submit pre-filed testimony for the administrator. So that raises the question of whether or not the board wants to preclude the administrator from just having a discussion because he was not part of a witness list.
Okay. Mr. Scherer, do you have a response?
I would suggest, and we're not going to object to Mr. Messel testifying, even though he wasn't on the witness list. I would suggest he did submit pre-file testimony. The whole point of pre-file testimony was so that we read all the facts out and be able to expedite and make this process more efficient. And that is, again, Mr. Park, the Administrator Park, we're not going to object certainly to him. He submitted pre-file testimony. But we discussed at length Sandbank. And we have no questions for Mr. Bell. were willing to rely on his deposition. Any questions they had could have been asked in his deposition. They did not. The only reason for them calling here today is so that they can try and expand the record.
So here's what we're gonna do. I'm not gonna allow him to expand the record. He's gonna be limited to the testimony that he's previously given in his deposition. I'm gonna change the procedural posture though for this witness. I'm gonna allow the witness to testify. But what I'm gonna do is Mr. Yorio, you're gonna have to do your direct of Mr. Bell. And we're gonna do it that way as opposed to when we have the pre-filed testimony that's submitted as being the direct examination of that witness. So then any cross or anything like that's going to be limited to the direct or what's present in his deposition. So you can proceed, Mr. Yorio.
Thank you.
So I'm overruling the objection and allowing Mr. Bell to testify. And I guess I'll put another point of fact on the record just so that we have it. If anybody wants to look at this at a later date. I think that notice was met. Notice was met because he is listed as a witness and his deposition was taken. So you obviously did have actual notice that he was going to be a witness at the time of the hearing and you were able to take his deposition. That's why I'm allowing it to proceed.
Thank you. May I proceed?
Madam Court Reporter, if you'd swear in the witness.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Mr. Bell, what is your present affiliation with Captain?
Independent contractor. And I also on the board.
And how long have you been board member and part owner?
Since over 2022.
And has your family group of companies, the Bell companies, been an operator in Las Vegas for some time? How long has that been?
I'm sorry.
How did it come to pass that you had licensing discussions with Mark James?
Back in 2021, he noticed our companies as well as of patents.
And when do you recall, how did it come to pass that you were authorized to have discussions with Mr. James about licensing?
After having discussions with Andrew and the board, I brought to light that Mark and I had his previous affiliation with his limousine company that he was operating for the Frias family. We had an IP run-in before, and we resolved it amicably without any legal, other than coming together and working out a solution. And because of successful negotiating with him in the past, I thought it would made sense for us to give it another try.
And your reference to Andrew in that answer was Mr. Myers? Andrew
Yes.
Myers. And at what point in time did the substantive discussions with Mr. James get to the point of discussing possible royalty?
That would have been October, November of 2024.
And what was discussed between you and Mr. James about the subject of possible royalty rates that might be applied to IVSC patents?
Well, it was a very long, there's months and months and months of negotiation there, but we started off with the fact that he has a very wide breadth of patents. And he needed to be compensated for those patents, and he wanted to have the same result as we had in our previous interaction and not take us to court. And so that's why he reached out to us first and was going to give us this opportunity to have a discussion. The discussions, started with statistical data that he gave me from some patent resources. I can't remember the name, but there was, he was providing me documentation and industry knowledge of ranges of where these normally settle at when they, different industries. And the range was, 3 to 6%. And then we had to also deal with the back royalties for, back a number of years. So, just through constant back and forth and discussing fact, how devastating, it would be to the industry to lose the technology through and not being able to come to some sort of a resolution. And then the fact that, we just kept going back and forth, and, he has people that are, that he, on his side that were advising him. And, we just finally got to a point where he went below the minimum in that range and got rid of the royalties. And I truly felt like that was a really solid offer for, considering the big backlog in royalties and considering the range. I thought it was extremely fair. And then after we had kind of settled on that, in the very beginning, it was more of, that the 50-cent fee is the 50-cent fee. And then we just started discussing how we were going to collect it and how the technology is going to have, there's going to have to be some modification to the technology to ingest it and accurately account for it. And in the beginning of that negotiation, I want to say it was like 1 or 2 cents per transaction for Captain to facilitate that. And then it was some months later, I was, I had reached out to some other software people that I knew in the industry and had mentioned to them kind of what I was going through, what Captain was going through. And one of them said to me that, we've been discussing with our regulatory body in California the fact that, we want to create a technology fee. And I listened, and it was, we're not compensated well. Our clients are under assault from Uber. Business has been tough. It's hard to raise rates. And that gave me the idea to go back to Mr. James and kind of broach it with him. At this point, our negotiations were basically done. And so I went back to him and I said, hey, you built technology, you understand the challenges, you understand the finances, engineering, right? And what do you think about giving a more substantive piece of this 50 cents, if it in fact gets passed, to the software providers instead of just the 1 or 2 cents to process the transaction? And he said, let me think about it. And he took a couple of weeks and came back and said, you know what? And I didn't even discuss, it was very broad, just something more than 2 cents, 1 or 2 cents. And he came back and said, I talked to my team and want to give back to the industry 25 cents, into the technology side of the industry 25 cents. After listening to the commissioner yesterday, and I feel like that kind of went sideways with, all technology fees need to go to the state. It was really a term art, right? Like, we're technology companies, and he wanted to take a portion of that 50 cents, give it to us as a way to continue to push the industry forward and not have this everything is so negative and put some sort of a positive spin on a negative situation.
You said in that testimony, I think you referred to 25 cents. Did you?
25%,
20.
excuse me.
And earlier in your test answer there, you mentioned that the 50 cent per ride fee was lower, below the lowest settlement royalty that from the statistics that have been provided.
Correct. It was 2.5 cents and the lowest of the range was 3%.
And in terms of what Mr. James first asked was for a royalty, did he put that in dollars and cents per ride or a royalty rate or some combination?
In the very beginning, it was very broad. We didn't have any idea how to, we didn't know what we were going to do. We just needed to figure that out. And I was the one that came up with the concept of a pass-through fee. And then I think because his range, I don't know at what point in time we got to his, 6% calculation, which was like $1.20. But at one point, he was very high on that range and he would reference the back royalties. Like we can have something lower, but then you've got to have an upfront payment to deal with the back royalties. And obviously I was trying to avoid that at all costs. And so I would much rather have it moving forward to have big upfront payment to cure the back.
Did Mr. James indicate to you how far back in terms of years damages could possibly be asserted?
6 years is what
With respect to the fee that's proposed in this application, do you have a view as to whether, if it's approved, it would hurt competitiveness between operators and Uber and Lyft?
Yeah, I don't.
Objection, this goes beyond the scope of the deposition.
I think he gave testimony about that it was not anti-competitive for the operators.
Okay, show me in his deposition where is that? Michelle, could you read me the question back?
Question, with respect to the fee that's proposed in this application, do you have a view as to whether, if it's approved, it would hurt competitiveness between operators and Uber and Lyft?
don't think he mentioned Uber in particular, but he did indicate that he wanted to take into account the interests of the operators, their economic situation. And
So I think page 60 of his testimony, he talks about a Hobson's choice when he's trying to make a decision between the 50
Yes.
cents. And he says that it has an issue as to utilize captain services in a competitive marketplace. So I'm going to overrule the objection and allow him to testify.
thank you. Could you read the question? Witness, please?
Question. With respect to the fee that's proposed in this application, do you have a view as to whether if it's approved, it would hurt competitiveness between operators and Uber and Lyft?
I don't believe it will hurt our competitiveness at all. The 50 cents is very minor in comparison to the average rate. Uber and Lyft charge whatever they want, whenever they want, however they want. I think what would hurt us is the loss of the technology and the convenience that is way more important to keep us competitive with Uber and Lyft rather than a 50-cent charge.
Did you attend a meeting that Captain organized with respect to operators in Clark County? And was there one or two meetings that occurred? Did you attend both of them?
Both.
And with respect to the first meeting, what information was provided to the attendees?
We provided the negotiation timelines, what we had discussed. We provided all the patents for everyone to review. We provided our current state of negotiation with Mr. James. We provided the fact that, what we felt as an industry, what we've always done is to come together as an industry, put our heads together and try to solve these problems. And that's all we were trying to do. That it was going to be, the alternative was, in our minds, not an option. Having multiple lawsuits, millions of dollars have to spend to defend ourselves, and with very little, if any, light at the end of that tunnel to even win that lawsuit.
Did Mr. James indicate to you in his discussions what he believed the dollar amount of damages for past actions would be?
Objection meetings.
Over.
I don't know where, I don't know if that came from him or not, honestly. If he gave me I know there's the $40 million number out there I heard yesterday, but I don't know if that came from Mr. James.
Now, prior to your position with Captain as an independent contractor and board member, were the Bell companies, did they use Captain technology during the time you were involved?
Yes, we do.
And from your point of view as an operator, were you satisfied with the technology that was developed and improved by Captain?
Very satisfied. That team of engineers, and I had two sides. I had the limousine side and I had the taxi cab side. The Captain guys on the taxi cab side would very frequently sit down with us as operators, as groups, as individuals, and constantly take our input on different features, different things that we wanted. Business is constantly changing. We constantly needed more. Yet, of course, being the operator, I don't want to pay.
And did the time that you were involved in the Bell companies on the as the operating side, did the technology that was implemented by Captain provide any savings, reducing costs to your companies?
Absolutely. There was tons of efficiencies on the paperwork side of our business, going to electronic trip sheets. But I think the biggest advantage is were on the revenue side. That, there was, a lot of driver efficiency build outs that are still very popular and in need. But then the revenue generating side was astronomical.
If the pass-through fee that's the subject of this application is approved, your view as to what benefits to the public would be obtained?
Biggest benefit to the public is for us not to go backwards. The safety, the security, the ability for us to get cars quickly to our customers. All of that is built through Captain technology. And if that's lost, it's going to be substantially, it's like we're going to go back to the 80s and the 90s technology.
And with respect to, from the operator's perspective, do you have a view as to if operators would be harmed if this application is not approved?
What was that again?
Do you have a view as to how operators, as opposed to riding public, be affected if this
Checking out
application?
all licensees.
Yes,
Okay.
I did.
All the efficiencies that they've built into the system that allowed us to quit hiring staff on the back office side all of that would get reversed. The revenue generating side with the quick ride program, the over the air updates would go away. The labor that we spend, even the labor for the TA, you think about all of the ability to update all the meters on a rate change. Like I would spend thousands and thousands of dollars in overtime because every meter would have to get done at one shot. And the TA would have massive overtime because they'd have to be there to seal the meters. All those efficiencies go away back to really, really old.
No further questions.
Comes right.
Just have a couple clarification questions for the record. Mr. Bell, you took point on negotiations with Mark James, correct? Okay, and the 12.5 cents, as you testified, was something that was proposed by Mark James in response to the Captain technology and costs and advances that it was making?
Wasn't proposed by Mark. It was proposed by me after I had discussions with a California operator who had been discussing with the SMFTA about putting a technology fee in for them. We're doing all these integrations with Uber, and it's expensive. And so they have raised a considerable amount of money and they're frustrated at their ability to monetize due to the climate, due to the, our industry just being, hurt by Uber and Lyft. So he made the suggestion to me that something he was working on, and it clicked with me. I then went to Mark, said, hey, this is something that was mentioned to me. And he said he would take it under advisement, and he did.
And the impetus of that fee is so that Captain and or other tech service providers wouldn't have to go back to the operators and raise rates. Is that correct?
Correct.
Okay. And that 12.5 cent fee, that wasn't even negotiated until midsummer, correct?
Sustained.
Honestly, it was very
No,
late.
hold on. She's got to ask a new.
When was the 12.5 cent fee negotiated?
It was, I know our negotiations. We had already come to the 50 cent, like that negotiation was done. I cannot remember the timeframe, but we had already set on the 50 cents. And I want to say it was 2 cents at that point for processing the transaction. And then I came back to him with the proposal to increase it.
Do you know when the amended application was filed in this case? Would March, for the record, March 5th, 2025? Does that sound correct? Was the 12.5 cents discussed after the amended application was filed?
March of 25. I think it was. I literally can't remember when. Just can't remember.
But
I don't want to.
was Mr. Balaban at any point in time present for those discussions?
No.
Thank you. No question.
Shulman,
No question.
Mr. Sure.
Morning, Mr. Bell.
Morning.
Just to clarify, I didn't hear, and I think maybe you clarified it. How long have you been on the board of captain?
On the board of captains since when it's right when I came on board, same time. So October of 2022.
And how long has your family had an ownership interest in captain?
Ownership started 2020.
And a different family member was on the board of directors of captain
Yes.
between October of 2021 and 2022. Said in 2021, I believe that Bell received notice of violations of a violation of the IVSC patents.
Correct.
How did you receive that notification?
My cousin Brent got the notification. I don't know how he was notified. I don't know if it was. I would think he was mailed a letter, but I don't know.
So you don't know that.
I don't know.
He told you.
He brought me in and said, we got to deal with this.
Was he the family member that was on the board of captain at the time?
He was.
So is it possible that he may have been made aware of the letter that captain received?
Calls for speculation.
I know we received a letter.
Well, I'm gonna.
Why wasn't that letter produced? If there was a separate letter to Bell, why wasn't that letter produced as part of this proceeding?
Well, he'll clarify it if it is. So I'm gonna overrule the objection.
I was never asked.
But that was in 2021, is that correct? And are you currently a certificated taxi cab operator in Clark County?
No.
And when did that cease?
That ceased about 6 months ago. 9 months ago.
And how did that come about?
Our family was looking at the industry and looking at, this whole situation coming down the pipe, the Paradise transportation tunnel situation, continued pressure from Uber and Lyft, And, you know, we had had a sale fall through because of COVID. And so we never really weren't for sale. That sale just didn't happen. And we had interest and we took the opportunity to get out,
And who expressed the interest?
our entire board.
Who expressed the interest in buying the company or buying the assets?
There was multiple.
Okay.
Multiple different, you know, a couple of them fell out, a couple of them filled in behind them and actually did the deal.
And who did you sell the Clark County taxi cab assets to?
To Bill George.
And
sorry.
Bill George, Z-Trip.
his company is Z-Trip. That was my next question. And when did those negotiations with Z-Trip commence?
I don't know. I wasn't
Objection.
involved.
This line of question going beyond direct and beyond.
Give a response, Mr. Chair.
This goes directly to the questions that he was asked with regard to his view as an operator, number one. And it also goes directly to his credibility of his testimony and his motivations.
Negotiations with Mr. George and Z-Trip, not talking position, was not asked.
So that's how we'll limit it. You want to go into his background and that sort of thing in terms of the industry, that sort of thing, and what, you know, what kind of foundation he has to make statements as to the industry, that sort of thing. I'll let you do that, but I think that unless you can direct me to someplace in his testimony that he talks about the actual negotiations or the transaction with Z-Trip, then I'm going to sustain the objection as to that line of questioning.
Very well.
Understood?
Understood.
Okay, thank you.
Now, I think you testified earlier, Mr. Bell, that you met with Mr. James to discuss how to resolve the IBSC allegations of infringement of its patents, correct? And that he provided you statistical data showing a range of where they normally settle these kinds of cases.
Correct.
And I think you said that was, he also mentioned the possibility of back royalties. And did you do any independent research to confirm that what Mr. James is telling you was accurate?
I took it to both of our councils.
And who's that?
You're with Carl Farrell and Ian and Neil at Harris Beach.
Okay. So that's captain's councils,
Correct.
not the Bell Company's councils.
Correct.
When you and what did they tell you?
I'm going to sustain it. You can lay some more foundation. Why it would be excluded as attorney-client privilege, but as of right now, I'm going to sustain it.
In your testimony earlier, I think you also said that Mr. James said that damages could go back 6 years.
Yes.
And I think you also said that you were trying to avoid back royalties at all costs.
Yes.
In the sale of the Bell taxi cab operations in Clark County to Z-Trip, was that an asset sale?
Yes.
Objection to the questions about the negotiations and transactions. Beyond.
I'm going to allow him a little bit. I'm going to overrule the objection. I'm going to allow it. I think he's trying to lay foundation for another question, but it is going to be limited according to my previous ruling, Mr. Chair.
Understood. So if you closed the transaction 6 to 9 months ago with Z-Trip and back royalties could go back up to 6 years, would that mean that the Bell companies would have been responsible for the back royalties beyond the time of the closing of the transaction?
Objection calls for a legal conclusion and it's beyond the scope of the
I'm going to sustain the,
Your Honor, he testified that he was trying to avoid back royalties at all costs.
Okay.
Uh,
you can ask him why.
Mr. Bell, why were you trying to avoid back royalties at all costs?
It's, why would I put with my captain hat on, why would I put all of our operators at risk of having to come up with a huge number to pay instead of just paying it forward?
Did your Bell hat come into that calculation at all?
No.
You mentioned earlier that the detriment to the industry would be the loss of technology and that efficiencies would go away.
Correct.
When you make that statement, are you assuming that there is no other technology that could take the place of Captain?
Yes.
And why do you believe that there's no other technology that could take the place of Captain?
Because I believe that the best way I could put it is I discussed the breadth and width of this patent portfolio. And it is large and it is detailed and covers a lot of what we do. I feel like it's akin to going into a baseball game and, the pros do it now at the end of the baseball game. They bring in the shortstop because they're going to lose. So they bring the shortstop in and he just lobs balls in. I feel like you'd have a better chance of the shortstop throwing an entire complete game no hitter than you would to be able to get out from underneath every single one of those patents, no matter what company, what technology.
I think you testified earlier and in your deposition, you're not a patent lawyer.
Nope.
You're not a patent expert.
Nope.
Why, if you became aware of the alleged patent infringement in 2021, did you not engage in negotiations with Mr. James until 2024?
We expected, we gave it to both of our technology providers on both sides of the house, Limousine, Captain. We knew we had indemnifications. And we, with our in-house counsel, discussed that, they're indemnifying us and now they have the right to go and negotiate a settlement in that provision. And we expected that to happen.
Thank you. I have no further questions.
Thank you, Mr. Chair. Ms. Carroll?
Morning, Mr. Bell. I don't know if you remember me. Okay, perfect. So to make sure that we have that established, I kind of want to go through the timeline that you have discussed this morning, because I kind of want to make sure that I understand the progression of events, and I also want to understand the different parties that have been discussed. Okay. So to start, when you're working in capacity of representing Captain, and you received, if I understand your testimony correctly, Captain receives a letter from IDOC alleging patent infringement, correct? and to kind of get an idea of who Mr. James is. Is Mr. James the patent owner or was he just the representative of IVFC?
He's the,
Okay. And you had, if I understand correctly, you had a meeting, 2 meetings with Mr. James to discuss this demand letter. Is that correct?
probably 100.
Oh, you had 100 meetings. Okay. And did these excuse me, let me rephrase. And you also had, was it 2 meetings with industry? Correct? Okay, so just make sure I have it understood. Did you have any meetings with industry prior to having any negotiations with Mr. James?
I did.
Okay. Can you please explain to me, so I understand this timeline, when did you have those meetings with industry and when did you have those meetings with Mr. James?
Meeting with Mr. James, I want to say started early, sometime in October, November. And it probably took, I don't know, maybe 3 weeks of weekly meetings, maybe a month of meetings with Mr. James before we brought industry into. And we had our first industry meeting, roughly 3 to 4 weeks.
So going back to the first industry meeting, did you have a proposed solution for industry to review at the time?
I don't know if it was the first meeting or the second, meeting, honestly.
Okay.
My inclination is I did have at the first meeting, but not 100% sure. Can't remember if it was the first or the second.
But and to make sure I understand, by the second meeting, you did have the, when is it, a 50-cent pass-through fee proposal prepared for industry. At any, I would say at any time between your initial discussion with Mr. James in October and November to when you had the proposed solution with industry by the second meeting.
What year is that, October, November?
Oh, thank you. Between that time period, did you receive any permission from any operators to negotiate on their behalf?
I have the contractual right to negotiate on their behalf. It's right in their MSA.
So, and just so I understand the MSA correctly, or actually,
Let me answer, but I did have, there was, I don't want to say consensus, but there definitely was multiple operators that wanted me to continue to try to chip away and to negotiate the best deal that we could. Now, was that in the first meeting, the second meeting? I can't remember, but for sure there was operators that called me after the meetings and have told me how appreciative they were of my work and that they knew it wasn't something that any of them wanted to do and keep working.
were any of the operators given an opportunity to join in the discussions with Mr. James?
I believe that I know for sure the option was there and it was brought up. No one was interested.
Can you explain to me how that option was brought up? Was it verbally presented or was it presented in writing?
No, verbally presented in those operators.
And do you recall if it was during the first meeting or the second meeting? You don't recall? Now, Mr. Bell, when you presented the solution to taxi cab operators, were you given the impression that they would enter into a separate agreement with the patent holder as part of the solution?
They would be given a license. Yes.
Do you know if the license would come through you as the software provider for Captain or?
No, it would come from IVSC.
And are you aware of any opportunities that operators may have had to address that agreement style with IVSC?
I'm not aware of, we've only got it first in a draft form. I'm sure as if this was to move forward, they could all participate in that directly with IBS.
And Mr. Bell, I believe during the course of your testimony, there was a discussion of a letter sent from IVFC to the Bell Group. Is that accurate? And and just so I can understand the players better, the Bell Group is separate from Captain, correct? Okay. And the letter from IVFC to the Bell Group, I believe that there may have been testimony that was received in 2021, but I wasn't sure how confident you were in that timeline. So I like to use was it before COVID or after COVID?
It's definitely.
Okay. So just so I can understand your familiarity with these different demand letters from IVFC. You received a demand letter from IVFC, or you've seen a demand letter from IVFC to the Bell Group. Is that accurate? And then you've seen a demand letter from IVFC to Captain. Is that accurate? Are you aware if there was any references to any cases or case law where IVFC is saying, like, I have been successful in enforcing my patent in these areas? As you sit today with what knowledge you have given, and you don't have to give me any attorney-client privilege if you're not comfortable, I just want to know, are you aware of any current litigation or separate regulation outside of this board where IVFC has tried to enforce their patents? No further questions. Thank you.
Any redirect, Mr.
With respect to the 2021 letter that was sent to Peacock by IVSC, were you aware if there was any engagement by Captain or its counsel with IVSC after that letter was received?
There was engagement.
And do you know if requests were made for further analysis or information from IVSC, Captain or its counsel?
There was.
And do you know if at that time, 2021, whether IVSC or its counsel provided that analysis or information?
Yeah.
In 2021?
I don't know if it came to 2021 or 2022, but, oh, not in 2020. Yes, in 2021, yes.
Do you know if the IVSC or their counsel provided any
Oh, IVSC?
IVSC?
No.
I'm sorry, let me restart. Do you know if any analysis or information further was provided by IVSC or its counsel after being contacted?
Only the patents themselves is what I remember.
Thank you. Nothing further.
But based on Deputy Attorney General Garrett's questions.
Okay.
Morning, Mr. Bell. My name is Neil Tomlinson, for the record, representing IVSC IP LLC. Mr. Bell, the meeting that you discussed with Deputy Attorney General Garrett, that was, I guess it was in the fall of 2024 with the operators. Was Jonathan Schwartz at that meeting?
He was.
Was Kimberly Rushton at that meeting?
She was.
Was it an LOA meeting?
There was LOA members there. There was also other members that. Yeah, there was not there, but my recollection, all the LOA members.
Thank you.
Any follow-up, Ms. Remser?
Absolutely.
Mr. Urio?
Nothing further.
Mr. Sure, any follow-up on the question?
Nothing further. Thank you.
I forgot with Mr. Brondinero to ask if my other member, Mr. Decker, had any questions, so I may call him back for that purpose after we have a break. So I'm going to allow Mr. Member Decker to ask his questions.
I had one question for Mr. Bolsonaro, but it was asked and answered by one of the attorneys.
Okay.
So, Mr. Bell, I appreciate you being here and testifying. You mentioned going back to the 90s. Are the operators who are not using the Captain product using tech from the 90s as you described, or is there a competitor?
They're not using technology from the 90s, but it's my belief that we are all in violation
Violation of,
of the patents.
so the other tech companies might be subject to the same allegations that you are.
Correct.
Okay. Can you explain to me how all the operators, including ones that may not be using Captain Tech, could be harmed if Captain's Tech became unusable?
Because theirs is going to become unusable.
Okay. When you mentioned how 50-cent or settlement proposal was fair. I want to talk about a little bit about that. The pass-through fee absolves Captain of basically the alleged infringement liability and any financial obligation. Is that correct?
And every other operator and every other software provider keeps
Well-
our industry intact. This is not a Captain issue. We're just the ones that were fortunate enough for Mr. James to pick us to send letters to.
So as of now, there are no other, the patent holder hasn't made any allegations against other tech companies that you're aware of?
To my knowledge.
Okay. So we'll focus on what's currently before us. Was the pass-through fee idea proposed before or after arriving at the 50-cent fee?
Before.
So I just want to clarify based on some maybe me not paying attention or some conflicting testimony. The 50-cent does include back royalties.
Takes those into account for sure. So if we were to sign, if this board was to pass this, then there would be no back royalties for anything.
Well, for Captain, correct? In the proposal,
I understand you want to keep saying that, and with all due respect, I think it's just completely unfair. I mean, the questioning of Andrew yesterday and the validity or the solvency of the company and everything else, all, I can't be strong enough in my, assertion to you that my relationship and past with Mr. Mark James and being able to negotiate successfully a license that was, 10, 15 years ago is the reason why that the Bells and Captain got this letter. And so, yes, I feel for the board in this hearings, as industry, we've always come together as a group and sat down and hammered this stuff out and came to you with a unified voice and said, you know what, like, this is what our situation is, and this is our best effort to solve this situation. And that just simply isn't, it's befuddling to me, honestly, that we're not, but it is what it is. And so for that, I understand the questioning, I understand the constant, focus on Captain, but I can't tell you enough that it is just, in my opinion, 100% unfair.
is it your opinion that the proposed settlement agreement includes technology providers other than Captain?
Yes.
Can you, if I give you a copy, can you point to me where where?
The granting of their license. They're going to be in those documents. So one of those documents, they are granted a license. So the technology provider, as long as the fleet collects the fee, the technology provider takes their 12.5 cents and passes the rest along to IVSC. That's the construct the fleet gets a license, and as long as they pass that through to the provider, and the provider continues to pass it through to Mr. James, everybody stays, no one is sued, and that's the agreement. So no, there is no risk.
Okay, I'll let one of the attorneys go through the settlement agreement. It looked to me in reading it that the recipient of the 12.5 cents technology fee was Captain. Is that incorrect?
In this instance, and because we're dealing with Mr. Ballard, then it would be Captain.
So you're saying there are other technology companies that could be subject to allegations of patent infringement, but they would have to propose their own pass-through fee.
If this is approved by the board, they would then do exactly like Captain is going to. They would get the 12.5 cents. The remainder would go to IVSC.
Okay. Do you feel the 50-cent fee would be a fair settlement if Captain itself was incurring the cost?
No, couldn't afford. And that's why, listen, if there's somebody to blame in this whole 50 cents fee, it's me. I came up with it because the public is the only one, in my opinion, being an operator and being in this business for 32 years. The public is the only one that can pay it because it's fractionalized into the millions. That's the facts.
So I understand that the argument is based on need, but you mentioned the word fair. You feel it's fair for future writers to pay for back royalties and the liability or the obligation that is alleged the patent infringement?
I feel like it is fair. I feel like the public has been given a tremendous amount of technology, convenience, and you don't have to go back very far in our history when we were doing things much differently in this industry. And the technology firms, not just Captain, all of them have built amazing technology that has pushed us forward. As far forward as it has pushed us, we're still behind. We're still behind Lyft and Uber. And we don't have private equity firms that we can just go spend hundreds of millions of dollars building tech. And that's just the simple truth of it. They're completely unregulated. They act like they change their pricing when they want to. They change their algorithms. We don't have any of those options to us. Just don't. And if we did, we wouldn't be here. We could change pricing on demand as quickly and as frequently as Uber and Lyft did. We wouldn't need to be here. We would have negotiated with Mark. We would have sent out terms and conditions to our clients and said, this is the new deal. And they would have had to adjust it. I mean, Chairman Reeser made a very good point, yesterday about passing those, doing it a different way. But I got to tell you, there's 1,000 years of freaking people in this room with taxi cab knowledge. And I tried to get every single one of them together, and not one of them made that suggestion. And that includes me. And I've been in the industry almost as long as most of these people. But we didn't come up with that solution. And so here we sit.
Thank you. No further questions.
I think some of the questions I saw yesterday was directed more at the 12.5 cents than it was anything else. And I think that, I guess my question is to that is, settlement with IVSC is for the 37.5 cents, right?
Nope. That's not my opinion.
And so and that's the question. What is it?
So I tried to reference a little bit when the chairman discussed the technology fee has to go to the state. So the impetus for the technology,
Let me stop you there just
Okay.
for a second.
Yep.
So, and for purposes of the record, I want to make sure that this is clear. There is such a thing as a technology fee that we've discussed at various meetings in this. You're trying to make a distinction between the technology fee and what you referenced previously as a technology fee.
Correct.
So if you would make that distinction on the record.
so the technology fee was more of a term of art, because we are technology companies, and
Specifically, you're referring to the technology fee that's referenced in the settlement agreement,
correct.
Okay.
Separate and aside from
the statutory technology fee that exists.
that goes to the,
Okay.
to you.
And I understand the distinction. So that's,
Okay.
that's kind of my question. And you don't have a copy of the settlement agreement in front of you. Can somebody give him a copy of Exhibit 6?
Yeah.
Mr. Bell, this is the settlement agreement that you helped to negotiate with Mr. James.
Yes.
Jason, these are all the exhibits and everything.
Oh,
on
for the
back.
witnesses. Thank you.
So. Thank everybody for picking up their papers.
Thank you.
This document, though, you'd agree that the parties are captain, the taxi operators collectively, and IVSC IP LLC, right?
Yes.
So as I understand your testimony, and clarify this if I'm incorrect, is that any other technology provider, whether it's Curb or anybody else, is included in this agreement or no?
They're not named in this agreement, but the thought behind this was if this was approved, that they would have this same option to negotiate or to license with Mr. James, the exact same way the captain did.
If you look at page 2, that's the breakdown of the 50 cents there.
Good. Yep.
And it says Roman numeral 2, subsection 2A says 37.5 cents per ride shall be remitted to the IVSC. Read that correctly?
Yes.
Okay. And it says 12.5 cents per ride shall be remitted to a technology service provider selected by each respected taxi cab operator. Did I read that correct?
You do.
So this agreement could be modified to include any other technology operator.
Correct.
Okay. So here's my question to you. When you were saying that there is no other technology provider that would be in violation of the patents that we're talking about here, the 5 that are listed on the page previously, right? So on the page previously, on the first page of this agreement, there's the 5 patents that Mr. James and IVSC IP is claiming. Is there any provider of a metering system in the United States not in violation of those patents?
In my opinion, no.
I would object to the extent calls for illegal.
And I'll sustain. I'll sustain the. And I'll ask a different question. Is there another provider that could come in and operate in Nevada, regardless of whether or not they're in violation of the patents?
Of course.
And you, as you're sitting here today, you're not aware of any other patent infringement demand letters that IVSC has sent to those other operators or those other technology providers?
I'm not.
Most of my questions have been asked. Just trying to get to the bottom. So at some point in time, Ms. Gary asked you some questions about this agreement and the ability of other technology providers and or operators to negotiate a separate agreement. Was that your testimony?
I mean, that's really for IVSC. It was, what we envisioned was this board dictating what would happen. Not, and that we were, I didn't go into these negotiations just for Captain. I went in with the mindset that we're all in this boat and we've just got to come with a solution, which is why I'm befuddled that there isn't more support, right? Because it does provide a solution that keeps everything as is, and I believe is minimal. But do I believe there's a world in which Curb or Z-Trip could go to Mr. James and say, look, we don't want to do that deal? Sure, they could.
So the applicant that we have in front of us and the application, the amended application that we have in front of us is a rate change for the industry as a whole. Do you have that understanding?
We might be parsing words here, but I do know that as a board, you have the right to authorize different rates. We don't all have to have the same rates. So if that was what the board decided, I would cherish the opportunity to allow Captain customers to be able to participate and for everybody else to go do their own deal with Mark James, see how well they negotiate. So I don't think this has to be an industry as whole solution because of the way that the law is, and it gives you the right or the ability to provide for different rates.
Okay. You have any follow-up, Chief? Okay. Unless somebody has some questions regarding Member Decker or my questions. Anybody?
No.
Mr. Sure?
No.
Scare? Okay. Thank you're excused, Mr. Bell. So you don't have any questions of Mr. Bonanero?
No.
So who's our next witness?
I believe it's going to be Mr. Noah myself.
All right, so let's do this because I figure that's going to be a bit. Let's go ahead and take our lunch break now. And then let's say we'll come back at 12:45 and start at 12:45. We have a notice issue on that or at all? Okay. So that's what we're going to do. We're going to take our break now. It's 11:35. We'll come back at 12:45 from the break and we'll start up with Mr. Massell. Who else do we have this afternoon for purposes of the record?
Purposes of the record, we have Jonathan Schwartz. It's a plane today, catch this afternoon, so that gives you one. Mark Malin. Vishal Dewan from Curb, we'd like to have him testify remotely in New York, but have him testify by
And
him.
we'll coordinate with, and have you coordinated actually with the secretary?
I have not.
Okay, so we'll do, can you do that on the break so that we can see? And he may not, that witness may not go today. They're gonna probably go in the morning, it sounds like, just because of all of the other witnesses.
We also have Mr. Bill George.
Okay.
And Cheryl Givens also submitted testimony.
Okay, so and is that the order you intend on going with?
I think Mr. George also has a flight tonight, so we might try to move him.
So
up.
those two witnesses that are, okay, so then that's what we'll do after Mr. Merrill. Massell, sorry. We'll go with those witnesses unless anybody objects.
No objection.
All right. Okay, we'll go off the record.